Dear students, today we'll be discussing the legal tenets contained in the Manusmriti. The objective behind today's discussion is to give you an understanding of the legal principles contained in the Manusmriti, to give you an insight about the intricacies of civil and criminal laws, as well as the various categories of laws, structure of punishment, and judicial proceedings. For the convenience of understanding, I have divided the entire discussion into a number of segments. We would start with the introduction of the text, then we would move on to the various kinds of laws, then we would move on Raj Dharma and the duty of the king, and then judicial procedure and the structure of punishment. Let us start with the text itself. What is Manusmriti and why is it called the Manav Dharma Shastra? Manusmriti is said to be one of the finest treatises on state and government. Manu was the first to systematize the science of government and administration. Manusmriti, or Manav Dharma Shastra as it is called, consists of 2685 verses divided into 12 chapters. It contains list of social obligations and duties of the various castes and of the individuals in their various stages of life. It also lays down guidelines for social conduct as well as rules for societal and political living. Manusmriti is considered to be an authoritative text on law. Manu is considered to be the first lawgiver. It is said that Manu was the progenitor of the human race, the first lawgiver, the first legislator to properly enunciate and systematize the rules of political system. The 8th and 9th chapters of the Manusmriti focuses on the various categories of laws and their applicability. These 18 titles of laws or grounds of litigations consists of about the various civil, criminal procedures. At the same time, they provide for the various intricacies of the legal system. Law is said to be the basis of society and polity. In fact, these Vivarapads take up 1/5 of the total book. Now, Manu had divided the entire system of laws into 18 categories and he calls them Vivarapads. The 18 categories of laws comprise of non-payment of debts, deposit and pledges, sale without ownership, concerns among partners, resumption of gifts, non-payment of wages, non-execution of agreements, recession of sale and purchase, dispute between owner and servants, dispute regarding boundaries, assault, defamation, theft, robbery, adultery, duties of man and wife, separation between man and wife, gambling and betting. These are the 18 categories of laws. Now, what is the basis of law? Manusmriti enunciate that dharma is the basis of law. He maintains that the moral aspect of dharma and righteousness is considered to be the basis of the legal system. The king should carefully consider the rules of various castes, local customs, bylaws in order to understand and apply law in various aspects of social and political life. If legal principles oppose the Vedas, the king should not uphold it. Justice was the basis of the social and political system. He puts great emphasis on the need to maintain justice and held that one who violates justice is always despicable. Manu also says that the king is the dispenser of justice. The king is the original court as well as the appellate tribunal. The king presides over the courts. However, he is assisted by Brahmins and counselors. Cases are to be decided in accordance with the principles of local usages, customs, and sacred laws. Manu's idea of justice encompasses the idea of social justice that we find in contemporary times. He called it the social purpose of justice, where the king must protect the rights of everyone, and he should ensure that people who are unable to protect their rights, the king comes to their rescue. He adds that it was the duty of the king to safeguard the inheritance and other forms of property of a minor until the latter returns from the guru's home. Property. If the owner has disappeared, the king would maintain the security of the property for 3 years. If the owner comes back within 3 years, the property may be given back to him. But if the owner does not return within 3 years, the king can consider it to be the state property. Judicial assemblies. The law court is considered to be an adjunct of the state. It was considered to be the basis of the social order. In fact, the judicial assemblies were considered to control and settle disputes between individuals and individuals, between individuals and owners of various associations. The smallest and the basic court was the village council. The village headman was in charge of the village assemblies, which would dispense justice pertaining to cases that come in that particular village. In fact, the village council was considered to be the basic court where litigants can approach and get their cases redressed. The king was to appoint a headman of 10 villages, and as salary for dispensing justice, he would be getting 1 kula of land. The king would also appoint the village headman of 20 villages, where he would be getting as salary 5 kulas. Similarly, the king would also appoint a headman of 100 villages, where he would enjoy an entire village as his salary. Finally, a king could also appoint a headman comprising of 1,000 villages, and this headman would be enjoying as his salary an entire town. However, Manu was exceptionally brilliant in understanding that it might not be possible for a village headman to settle all disputes that might come to him. If a village headman is unable to dispense a case, in case of doubt, in case of incompetency, the headman of the village shall refer it to the headman of 20 villages. If the headman of 20 villages are unable to decide the dispute, he may refer it to the headman of 100 villages. If the headman of 100 villages is unable to decide the dispute, the latter may take it up to the headman of 1,000 villages. If all of them are unable to decide the dispute, then they can take it up to the next higher level and approach the king in order to decide the case. Appointment of judges. Manu is very cautious about appointing the right person as judges. Manu was in favor of appointing Brahmins as judges. In exceptional circumstances, it was permissible to appoint a Kshatriya or a Vaishya as a judge. But Manu says that a Shudra can never be appointed as a judge. He was of the opinion that Dharma would come to ruin in such a situation. There was a logic behind this. Perhaps it was due to the denial of study of Vedas to the Shudras, and that was the reason maybe Manu had denied the right of judgeship to the Shudras. Raj Dharma. The legal system was based on Raj Dharma. It was the duty of the Raja, the king, to dispense justice. The king was told to decide law in accordance with the rules of the Shastras and usages in the country. Manu wanted the king and judges to inquire every case very diligently, and he asserted that a heavy fine would be imposed if a wrong punishment or a wrong judgment was given. Manu required the king to make good of his own treasury if the loss appeared to the plaintiff because of a wrong decision. Under no circumstances a wrong decision can be given by the court. The king is directly responsible for dispensing justice. It is the duty of the king to protect the people. In other words, by providing compensation to the aggrieved party in the event of a wrong judgment, The king is trying to set right some of the wrong that he might have committed in giving a wrong judgment. It is the duty of the king to protect the subjects, and dispensing justice is one way of protecting subjects. He who does not protect subjects and upsets the social order is considered to bring in grave ruin and disaster in the kingdom, because it is considered that power and power alone can be used in order to maintain justice. The king, when he uses his power impartially, can he maintain proper justice in the kingdom? The king who administers justice in accordance with the sacred law, and by sacred law he is referring to dharma, evidence, customs, he actually prospers and conquers the whole world. A king who properly inflicts punishment prospers through happiness, prosperity, well-being of one and all. Manu felt that judicial administration should not rest in the hands of a feeble-minded king. If judicial administration was given to such a feeble-minded king, justice would be destroyed and country would face a disaster. How were judicial decisions taken? 3 assessors were to be appointed by the king. Once again, Brahmins were to be appointed as assessors. Their opinion were to be taken in all important points, and under no circumstances judgments should be provided by a single person. The decisions of the judge should be based on equity, fairness. It should also take into account the diverse customs and practices prevalent in the country at that point of time. Coming to punishment, an important part of justice dispensation was punishment. Manu's ideas on social organization aimed at establishment of order, and you can maintain order in society when there is a proper structure of punishment. The king, having duly considered the time and place of the offense, the strength and knowledge of the offender, should justly inflict punishment on the offender. It was perceived that punishment and punishment only can control all human beings, and therefore utmost importance was given to punishment. The king, if he does not punish the offenders who were worthy of punishment, then the stronger would roast the weaker like a fish on a spit, and a situation will arise whereby the mighty would overpower the weak, and there would be no consideration of justice in such a kingdom. Manu provides certain stages of punishment. In fact, a person who has violated the legal norms may be provided punishment in various stages. First, by gentle admonition. Afterwards, by harsh reproof. Thirdly, by a fine. And finally, if it doesn't improve, corporal chastisement. When the offender is not able to restrain such offense, even by corporal chastisement, then the 4 modes of punishment can be jointly applied on the person. Now, Manu comes to the relationship between laws and varnashram system. Manu's ideas on varnashram is also reflected in the criminal laws. He prescribes different punishments for identical offences for different castes. Brahmins were exempted from capital punishment. Manu provided that different castes may be given different punishments, but he said that only under exceptional circumstances like self-defense and similar situations can law be taken in one's own hands. Besides capital punishment, he also proposed various other kinds of punishments. But all punishments, whether in the form of imprisonment or fines, should be executed after careful consideration. The king was supposed to maintain certain manners while dispensing justice. Manu provides a detailed analysis of the manner in which the king and the judges should proceed in dispensing justice. Manu's code says, a king desirous of investigating law courts must enter the court of justice, preserved in a dignified demeanor, properly dressed, together with Brahmins and experienced counselors. Therefore, he should ensure that everybody possesses the right kind of attitude and mental mindset before dispensing justice. Thereafter, either standing or sitting, raising the right arm with ostentation in his dress and ornaments, let him examine the business of the day. Manu cautions his king that justice being violated destroys the world. Justice being preserved preserves everything, and therefore under no circumstances justice should be violated. He opines that the only friend of a person was justice. If judicial system fails to dispense justice, Manu opines that 1/4 of the guilt of an unjust decision falls on him who committed the crime, 1/4 of the guilt falls on the witness, and 1/4 on all the judges, and 1/4 on the king. That means if you are giving wrong judgment, you cannot be absolved of the sin of that wrong punishment. You are a part of the entire procedure of dispensing judgment. Let's come to judicial proceedings now. The judicial proceedings comprises of 4 parts: complaint, reply, evidence, and judgment. 3 types of evidence are mentioned in the manusmithi: document, possession, and witnesses. Once the defendant denies the charges, the complainant should call for witnesses or other evidence. And in case of a conflict in witnesses' statements, the king should accept, in truth, the evidence provided by the majority. If there is no witness, the king and the judges should follow the policy of investigation. Now, who can be a witness? Manu says that trustworthy men of all the 4 castes or varnas can be made witnesses in various lawsuits. Men who have failed in their duties should never be made a witness. Women can give evidence against a woman. Twice-born men can give evidence against twice-born men. Virtuous Shudras can give evidence against virtuous Shudras, and men of lowest caste can give evidence against men of lowest caste. But a person who is unworthy of giving witness can never be called on the witness stand. On failure of a qualified witness, evidence may be given by a woman, an infant, by an aged person, a pupil, a relative, a slave, or a hired servant. This shows how much importance Manu gives to witnesses. But the judge should consider the witness of only those people who are trustworthy. Evidence taken by students, slaves should be considered only in the last resort. So we have understood who can be a witness. Now, who cannot be a witness? Outcast. One who has fallen from his varna cannot be a witness in any case. The king cannot be made a witness in a case, nor mechanics or actors be made a witness. A student of Vedas should not be made a witness. People who have given up all connection with this world should not be made a witness. People who have bad fame, doshus, aged people, people who follow forbidden occupation should not be made a witness. People who are extremely grieved, intoxicated, mad, tormented should not be made a witness, because you need a right mindset in order to give witness. There are certain areas where witnesses are not needed also. In case of violence, theft, adultery, defamation, assault, the competence of the witness may not be examined too strictly, rather other forms of evidence may be taken into consideration. Let us now come to rules for summoning. What are the rules for summoning a person? If the opponent or the defendant against whom a suit is filed, he should definitely be summoned to the court. Even other persons connected with the defendant should be summoned to court. However, some persons like soldiers, agriculturists who cannot come to the court when summoned, then they can send some of their representatives to appear in the court. In serious matters, the persons are allowed to appear in person before the court, but definitely with proper safeguards. In very, very serious cases, such as murder of a woman, adultery, it may so happen that a representative is allowed, but then the concerned person should come again when he is next summoned. There are other rules of summoning. A summons, when it has been served in the court, the king should wait for 30 days. And 15 days he should wait and pass the judgment if nobody who has been summoned comes and appears. In such a situation, the plaintiff may be offered a judgment. But suppose there is an invasion in the territory, there is a famine or an epidemic. The king should not fine the defendant for non-appearance in the court. Agents can be allowed to represent disabled masters. Let's come to intricacies of justice which Manu enunciated. Manusmriti has prescribed that part of the judge's function to probe into the heart of the accused. Why did the accused commit such a crime? Let him discover by studying the posture, mind, change in voice and eyes. In fact, these feelings, these exterior signs do tell a lot about the commission or non-commission of a crime. By external signs, let the king and the judge discover the internal disposition of man by their voice, color of the face, their motions, their aspects, their eyes, gestures, whether they have committed a crime or not. In fact, Manu says that what is going on in the mind of a culprit can be deciphered by looking into the external signs like gait, gestures, external signs as of speech, change in eye contact. And it is so very unique that Manu emphasizes on these gestures, gait, external signs to understand whether a person is guilty or not. It is further held that if you just try to understand the voice modulation, flattering of the voice, licking the corner of the lips, speaking incoherently, loss of color of the face, coughing often while acting as a witness, all these are various ways of understanding whether the person is guilty or not. What can we understand from these legal principles enunciated in the Manusmriti? The legal principles enunciated embrace the entire life of an individual. It is an integral part of Raj Dharma. Dharma is the basis of the legal system. Manu's analysis of the 18 Vyavharapads clearly establish the importance and significance of laws and their applicability. The legal principles are comprehensive, and so are his principles of justice, judicial procedures, and punishment. Since laws are the basis of society and polity, Manu laid utmost importance to procedures and modes of dispensing punishment. Justice to Manu should be as deserved, neither too harsh nor too lenient. The legal principles contained in the Manusmriti, though enunciated thousands of years ago, appear to be highly contemporary and modern in their orientation. Let us quickly sum up what we have studied, students. We have studied the various Vyavharapads. We have also studied how justice should be based on equity, fairness. We have also studied the various procedures. We have studied about the laws pertaining to summoning, the laws pertaining to witness, evidence. We also found that the king was the dispenser of justice, but he was not supposed to dispense justice individually, but he should be assisted by assessors or counselors. Witness, documents, evidence, these were various important procedures to be taken into account before dispensing justice. And finally, Manu emphasizes the fact that laws make a society and polity, and therefore proper and just legal principles make up a proper state and an administrative system. Thank you.